Hi, I'm Fred Tonelli.
And I'm Doreen.
Welcome to Hull on Estates. You're listening to episode number 624. Today we'll be discussing the Worsoff decision of September 2021 regarding remote versus in-person examinations for discovery and related topics about remote versus in-person court proceedings going forward.
Yeah, this is kind of the hot topic of the day, isn't it, Fred? The idea that, we're in a very different spot now, October 2021, or, back just a little bit ago in September 2021 at the time of this decision. We've come such a long way with being able to do so many things like through Zoom, virtual hearings, virtual examinations, even virtual trials. But we've also come such a long way, like in the pandemic, where with so many Ontarians being vaccinated, a lot of us are back out at restaurants again. People are going to movies again. People are at Blue Jays games again, apparently. That, a lot of the courts are actually returning back to like in-person proceedings as well. Coming from just a time where before COVID, every single step was in person. And then once COVID hit, every single step was virtual. And now we're in the spot where we're starting to get a mix of in person and virtual. What happens when people actually disagree about how any particular step should unfold now that we're in this new territory, maybe this new limbo time of September, October 2021? And that's what this case seeks to address. Why don't you give us a little bit about the dispute that underlies this Worsoff decision, Fred?
Sure. So in terms of this decision, what happened was the plaintiff was arguing that the examination for discovery in this proceeding should happen in person because an in-person discovery is more personable, it's less likely to be manipulated. There's going to be a lot more, human to human interaction that is not necessarily captured in a virtual examination for discovery as it would be in a hearing or any other step in litigation. And the defendants, on the other hand, argued to continue a remote examination for discovery as we've been doing for the past almost 2 years. Reason being, for one, the ongoing pandemic, there's obvious health issues here, and another being that the lawyer for one party is located in Toronto and the other one's located in Ottawa, and there's an obvious distance and convenience issue here. So in this decision, the judge essentially said that there's obviously a balance of convenience that goes on here. There is, a matter of, well, both sides have a legitimate argument. There is a chance for remote examinations to be manipulated and that evidence would not be as legitimate in that case. But at the same time, that the access to justice provided by remote proceedings, more generally speaking, has been the biggest step forward for making costs and legal proceedings more accessible to the average person since the 2014 Hriniak decision, which was referenced towards the end of this decision. And so the judge ultimately decided that on the balance of convenience, the defendants were correct and that this examination for discovery should proceed remotely rather than in person. And I think that this, brings up an interesting question, Doreen, and we can, go off this, is that it would be interesting to see going forward, obviously with the pandemic still ongoing, there's essentially judges are not going to, or courts are not going to question if someone says, I still want to do this over Zoom, I still want to do this remotely. But, as time goes on, I hope, in a year or two, this will all blow over and things will be relatively normal again. By what standard would clients or counsel be forced to attend in person? Because I think that there's some element of not going back from this in the sense that you don't necessarily need to drive from Toronto to Ottawa for a 10-minute scheduling appointment or something like that, right? And that this actually does make our legal system a lot more efficient in ways perhaps that we should have done 10 or even 20 years ago, right?
Right. And I think what this decision actually does it's a really good jump off point, I think, even for the bar to know that there is a new even method on how to resolve this type of dispute. Like in terms of like the procedures that have been put into place ever since, COVID did occur. The Rules Committee have introduced a new Rule 1.08 into the Rules of Civil Procedure, and it deals with how methods of attendance are now threefold. It can be done in person, it could be done by telephone, and it could be done by video in terms of hearings that are before the court. And when someone actually has to intervene, you have to ask a judge where there's a disagreement about the parties. This is where this new rule comes in. And Justice Myers gives us a very good idea in terms of like what judges are looking for when it comes to this type of dispute resolution, because it's not meant to be another layer of another court proceeding where then you're going to start arguing about, well, how should this dispute be resolved? How much more material should this be an in-person argument or virtual or not? And it's really intended to be a case conference and being resolved through very little material, with everybody just letting the court know why they think they need the method of attendance that, that they or their clients like prefer. Rule 1.086 actually gives us from A to H the factors in which a court is supposed to consider this question. And it has a lot to do with, just even like the availability of, what the alternative is to a person, right? Like we are always just kind of assuming that people are going to have access to these technologies, and that's not always the case. Like the preference for in-person hearings, that tends to do with issues of credibility, because the judge needs to see like the entire person's like body. Maybe if I'm lying right now, maybe my legs are all sorts of jittery, but the court may not be able to see that because they can't see the rest of me. And there's this idea that maybe that can be seen through an in-person trial. So all of this like gets weighed in this like Worsoff decision. And I think at the end of the day, this case is about examinations for discovery where credibility is not an issue. It's not about whether or not the trial is going to proceed in person. And at the end of the day, this is also an action under the simplified procedure. It means a lot less is at stake financially for the parties. You don't even get like the full 7 hours for discoveries under a simplified procedure. You're only entitled to about like 3 to 4 hours to keep costs down. And if the whole point is to keep costs down, having counsel from Ottawa drive all the way in to do an examination for discovery in Toronto, well, that in itself kind of tips the scale like quite a bit, I think, in this decision. And at the end of the day, I think there is a lot to be said about counsel's view about what is the most effective way like they can conduct their practice, that they can advocate for their clients. And the court does have a lot of sympathies for that, but they also take into a lot of account for all the other factors that weigh in on the balance of things, as you've been saying, in terms of what this means for costs for everybody else, what this might mean for the administration of justice for all. And even just as of like a couple days ago, the Court of Appeal has announced that they are going to go back to in-person hearings as soon in November with formal practice directions to come. But when you read like what they have released about what their intentions are going to be going forward in terms of like the new model that they want to put into place, there's actually still leeway for counsel to opt out of being there in person, even though the full panel is going to be there. All the judges are going to be in downtown Toronto at Osgood again, but counsel does have the option of opting out of participating by Zoom, and they actually don't even have to give a reason why. And there is an actual specific acknowledgement from the top court in this province to say that there could be many reasons why counsel might choose to do this remotely. It could be concerns about illness, they might have childcare responsibilities, there might be travel difficulties. And I'm actually really happy to see this new flexibility going forward, that it might just continue to be like a hybrid model, what works best under any given situation. And if there comes to be a point where there are disagreements, kind of like in this Worsoff decision, then parties can go before the court in a case conference and have that be resolved in a quick manner. so that, this doesn't actually continue to like bog things down any more than things are already bogged down. This is a really a good decision to keep in mind as we hopefully continue to get better and we continue to have these options. And hopefully like technologies will improve for everybody as well, that more remote communities are actually getting like more access to internet, and that even like all of us are being driven to like learn new skills, be they like young or old. So this concludes our podcast. Until next time, we want to thank you for listening. I'm Doreen So.
And I'm Fred Tonelli.
Should you have any questions, please email us at info@hallandhall.com or leave a comment on our blog. Thanks, Fred.
Thanks, Doreen.